reminders for today. If you wouldn't mind just keeping your camera and mic off to just help with tech abilities while presenters are going, unless you are talking. And then it is wonderful to see you if you're able to turn your camera and mic on. Presenters will take questions at the end of their presentation. Go ahead and put those in the chat. And I'll help the presenters monitor those when they're done with their presentation. We record this meeting and it is posted to our website, tpchd.org/PCPC. And maybe someone forwarded this to you, or you just got linked into today and you want to know how to get this regularly in your calendar. You can sign up for announcements on our website. We are planning an annual conference later this year on October 23rd, and that is, please make sure you get these reminders so that you can get the information on how to register for our conference. Again, it will be October 23rd. So please, Kendra.
Arti duf arti swatwiftud atis poyalapabs, a slathlasil, alti disha tu alturi tuha.
It is the land right here that the Puyallup people have lived on since the beginning.
This
right here is where we are in the world, our homelands.
We work on our ancestral lands. We raise our children who go to school on the land of the Puyallup people.
We acknowledge that the Medicine Creek Treaty was signed for the whites to take our land for their benefit.
Land was assigned to our people. The Caucasians said, "This is your land," and they took that land from us too.
Our land was stolen from us. Treaties were broken.
But we are still here today.
Our people forage for food and materials, we pick berries, we canoe, we practice our traditional ways, and we speak Twelshutsi.
Just as our ancestors did.
We are finished.
All right, Camila, the floor is yours. Thank you so much for being here. And I'm going to make sure that you can share your own slides. And if you'd like us to share your slides, we're happy to.
Okay, I'm going to try to share. Can you guys see the window there? Okay, awesome. So my name is Camila Maturana. I am
Sorry, what we can see is like the whole thing with the slides on the side if you want to go into presenter mode.
Okay, let me see if I remember how to do this.
Just click slideshow on the top right. Oh, there you go. Perfect.
Oh, this one? Okay, thank you so much.
Got it. Thank you.
Okay. So my name is Camila Maturana. I'm an attorney with the Northwest Immigrant Rights Project here in Tacoma. I'm one of the supervising attorneys at the Tacoma and South Unit. And the Northwest Immigrant Rights Project, you may or may not have heard about us. We are a nonprofit organization. We provide free direct representation. We also engage in impact litigation, community education, other types of advocacy. Direct legal services are representing people in front of the immigration court, helping them on bond hearings in front of the in front of the immigration court at the detention center, and submitting applications, what we call affirmative applications, in front of U.S. Citizenship and Immigration Services. We have 4 offices. We have an office in Seattle, Tacoma, Granger, and Wenatchee. And the Tacoma office, we represent the southwestern quadrant of the state and the folks on the Olympic Peninsula. So if you have clients in that service area who you think might benefit from our services, you can refer them directly to our office. If you have any clients who are detained or who have family members who are detained, you can also refer them to our office if they're detained here at the Northwest Detention Center in Tacoma. So today I've done this presentation a few times, and I think it is helpful if possible if I pause for questions and maybe do some hypos and make it a little more interaction and a little more interactive, because it can be a little bit dry, and I think people sometimes have questions and they forget towards the end. So if you have any questions during the presentation, I will be stopping for questions after each section. So feel free to add them in the chat and I'll try to answer them, or unmute yourself and ask them after a little slide pops up that says questions. So today I'll be covering some recommendations on how to prepare your organization for ICE presence, for ICE coming to your office and stating that they want to arrest somebody or they want to search your office. We're also going to do a overview of rights that immigrants have in Washington State and in the United States, and go over some recent developments in immigration law and immigration enforcement action that we've been seeing. I know it's a pretty intense time right now for immigrants, so I'll talk a little bit about what we've been seeing, and if you have any questions about that, I'll do my best to answer them as well. It is an evolving landscape. Every day something new happens, it feels like, so I try to stay as up to date as I can, but yeah, I'll do my best. Okay, so how can organizations prepare for ICE presence? One thing to keep in mind is that ICE needs a judicial warrant to enter or search any private area, even of an organization that is open to the public. So what we recommend doing is clearly marking what area you would consider to be private in your organization. For example, in our organization here in the Tacoma office, we have a reception area that is accessible to the public during our work hours. And then behind the reception area, we're kind of fortunate. We have 2 doors that can close, and you can't access those that part of the building without going through those doors. So we've marked on those doors, private, do not enter without permission. Another thing that people can do to really make it clear that this area is private is to verbally tell ICE if they do enter the building, you do not have permission to be here, please leave, this is a private area. And you can also, because that can be quite difficult for receptionists to be comfortable doing depending on their own status, you can have sort of a hierarchy. So you can direct the receptionist or whoever's at the front desk to tell ICE to stay where they are while they contact their supervisor, who can then give them the directive to leave. And I think it's also important to be aware that ICE will say that they have permission to enter, even if they don't really have a judicial warrant. They'll pressure whoever's at the front desk, whoever's talking to them, pressure them to allow them to enter. They might also start talking to people who are in the reception area, asking them questions, things like that. So it's important that whoever's at the front desk and whoever's in the organization who might be there present is trained on how to respond to sort of handling authority in a way that we're all comfortable with. So I think many people have seen this. Maybe you have, maybe you haven't, but This is a comparison between a judicial warrant versus an immigration warrant. And it's important that we understand the distinction because a judicial warrant gives any officer of the law the right to enter your facility without your permission. So you can tell them no, and they can still come on in, and it's legal under the law. It has to be a proper judicial warrant, so it has to be issued by a federal court who has jurisdiction over that location. This says Florida, but it would have to be Washington State, here in Washington State. And it would have to be specific, so it'd have to have the correct address. If it's a warrant to arrest a specific person, it has to have the correct name of that person on the warrant, and it has to be signed by a judge. On the other side is on the right side is the ICE warrant that we most commonly see ICE officers show up with this ICE warrant, not a proper judicial warrant. The ICE warrant, the Department of Homeland Security warrant, does not allow ICE permission to enter a building or a private area of a building without the express permission of whoever's in charge of the building, right? So they can say that we have permission to enter, and if the front desk person isn't trained up on saying, no, this is just an ICE warrant, I think most people would say, okay, you're an officer of the law, come on in. But this warrant itself, it has the seal Department of Homeland Security. It will say Immigration and Customs Enforcement. ICE is a sub-agency within the Department of Homeland Security. It will say warrant of removal, not arrest warrant or search warrant. And it will be signed by some sort of field office director instead of an actual judge. So these are some tips on we recommend that you make sure your employees or whoever's working at your agency is familiar with the distinction between a district court warrant or a federal warrant and a Department of Homeland Security warrant, an ICE warrant, because the federal district court warrant does allow, or federal court warrant does allow the ICE officers to enter without your consent. But if they just have this ICE warrant, they do need your consent to enter the building. And most of the time, they will just have the ICE warrant. Oops, I'm going backwards here. Okay. And so what is the legal basis for this excluding officers or ICE from private areas? Private areas such as homes and parts of the workplace that are only accessible by staff or to staff have the strongest protections. Those are really considered to be private, needing consent or one of those federal warrants in order to enter. So ICE must have this proper judicial warrant or consent, not both, or consent to enter a private area. The public areas or the sort of semi-public areas have weaker privacy protections. So they just need reasonable suspicion of some sort of immigration violation to detain or arrest somebody in those public areas. And we would call the reception area a semi-private area in that you can't exclude people from the reception area, but it's also open to the public. So people can come on in, ICE can come on in, they can start having conversations with somebody in the reception area. They can ask, where are you from? Things like that, until they're actually excluded and told that they need to leave that area. What should organizations do if ICE comes to the building? So I'm going to have a little advisory that our organization has posted at the end of this presentation. Generally speaking, we do recommend that you and your staff maybe take an hour, 45 minutes to go through just practicing, or planning on what to do if ICE does come into the building, and getting comfortable with the idea of informing them that they don't have permission to enter any private areas without a judicial warrant, learning how to recognize what those judicial warrants look like versus what an ICE warrant looks like, And then training staff not to just sort of accept the ICE agent's claim that this warrant is enough for them to go into the building without their consent. Making sure staff feel comfortable viewing the warrant or contacting somebody who's authorized to view the warrant and to exclude ICE from the organization. And then if you do run into the situation where you have people in the reception area, ICE starts talking to them or questioning them, you can always inform them that they have the right to remain silent. And you can usher clients into a private area of the building and deny ICE access to this. This is a little more confrontational. So again, this is something that you want to talk through with your employees or just to make sure that they're comfortable doing this and that they know what they should be doing. And then we do recommend that you just take a look at the physical landscape of your office and try to creatively brainstorm how to demarcate private areas because sometimes some offices don't really have doors. They're pretty open. And so the reception area, it's easy to go from the front doors into what might be more private areas of the building unless there's some sort of signage. So that could be a stand, it could be a sign on the wall. And then just really make sure that you don't, most agencies probably already do this, but make sure that there's no confidential area information in plain view. Make sure you planned what to do with your staff, and that you've identified who's authorized to allow ICE to enter, and that's very clearly communicated with whoever's at the front desk so that they know that to contact that person before allowing ICE officers to enter the building. Okay. I have some questions, so I'm gonna answer those questions first, and then we'll go into the hypo. Is employees only on doors that lock enough of a private indicator, or should signage be more direct? I think that should be enough of an indicator, and they can't enter locked areas with just the ICE warrant. So, if it's locked and it stayed locked, they'd have to break the door down in order to enter it. And they would not have consent to do, and if the front desk person did not give them consent to do that, the ICE warrant in and of itself would not give them consent to do that. So I think a locked door, employees only sign, that should be sufficient. Yeah, and same for Sonia's question. A lock unit, I would say that's considered a private area. You might want to add a sign to it just to make it very clear. But they're kind of what our legal director says, they're kind of like vampires, right? You think of ICE officers as vampires. They cannot come into a locked area unless they're allowed into that area with just an ICE warrant. Okay. So if ICE officers have shown up to your office, they state they have a warrant to search the facilities. They tell Paul, the front desk person, that he has to let them search the building. Paul asks to see their warrant, and the warrant has a seal stating Department of Homeland Security and is signed by a field office director. What do you think what next steps would you advise Paul to take, or can Paul take in this scenario? And you can just put it in the chat or unmute yourself if you have an idea. There's more than one correct answer. Oh. Okay, good. Yeah. I would say C and D are probably the best options. You can do both. He can just do C. It's up to him. Call the police is kind of a crapshoot. You don't really know who you're going to get if you call the police. So I would not recommend calling the police, but definitely ask the ICE officer to wait, or just tell them to leave the building, that they cannot enter. Okay, that's right. Field office director is not a judge. What if they attempt to barge in even when they are told they cannot enter? Great question. That can absolutely happen. So if they attempt to enter, we don't recommend that anyone try to physically stop an ICE officer from entering the building. Or what I would recommend is trying to get their badge number, maybe recording if your facility allows recording in the reception area. Just getting as much information about the field officers or whoever is the ICE officers as you can. You can contact our organization if that happens. If it's recorded, you can submit recordings as well. That would probably be a civil matter, so you'd probably have to sue ICE over that. They're aware that they can't enter with just a judicial warrant. I'm sorry, with just the ICE warrant. So they're aware that they need the judicial warrant in order to just barge in. I think especially if it's a medical facility, that would give rise to a lawsuit. So just gather as much information as you can if that happens. Okay, next typo. Three ICE officers have shown up to your office. They state that they have a warrant to search the facility. Two officers walk around the front desk and into the open area at the building behind the receptionist. The third officer begins talking to some clients sitting in front of the receptionist. How can the receptionist respond? Any ideas? Let's start with the first question. And if you want to mute yourself, you can unmute yourself too, I think. I think that's okay. Yeah, tell people they have the right to remain silent. Tell the clients that they don't need to talk to the officer. Ask them to record the interaction. I think that's a legitimate response. I think ask to see the warrant, call their supervisor, right to remain silent signs. That's for clients in the lobby. That's a great idea. You do not have permission exactly. So this is kind of like a multifaceted. There's a lot going on here, and this might happen, especially if multiple ICE officers show up. So I would say, have the receptionist say, "Hey, please wait first for the officers trying to enter the building," and then maybe handle the interaction with the clients and ask the officers not to speak with anyone until their supervisor is able to provide additional support. And then what can the organization do? What ideas do you have any ideas on what the organization can do just to support the receptionist in this situation? And this might be kind of a tricky question. I'll let you guys respond, but if people don't have ideas, I'll give some ideas. So I would recommend, having a sign if possible, because it is an open area. So you might want to, Sonia, exactly. You could have a sign posted behind the reception desk that any area behind the reception desk is private. And that could be like a stand, a sign on a stand. It could be a notice on the receptionist desk. It could be a notice on the wall. And that way the receptionist can point to the sign and just be like, "Hey, you guys can't go any further. This is a private area." It's also good to have maybe some sort of call tree, some sort of clear somebody that appointed to respond to that situation that the receptionist can contact and say, so they have something to tell the ICE officers, like, "Please wait, I need to contact, my supervisor," and that supervisor can respond to the ICE officers. And also just making sure that the receptionist is trained and feels confident to respond accordingly to any ICE officers who come to the facility. Okay, are there any other questions before we go on to the next slides? Okay, I'm gonna move on. If there are any, feel free to enter them and I'll answer them at the end of the next section. So interacting with ICE officers. If immigrants who are at risk of deportation find themselves in a situation where they are being interrogated by ICE officers, it's really important that they know that they have certain legal rights. So the number one right we always talk about is the right to remain silent. Everybody has the right to remain silent. You do have to affirmatively assert that right. So you have to say, I'm going to remain silent. I wish to speak to an attorney. And then it's really important that after they say that, they remain silent. And everybody, even people who are undocumented, have the right to privacy. So they have the right to bar immigration officials from entering private spaces without a warrant signed by a judge. We also recommend that people make a family plan in advance of, hopefully in advance of any type of immigration proceedings or contact with ICE. And I'll talk about that a little more in a few minutes. We also recommend, if you know you might have contact with ICE and it might not end well for you, try to contact an immigration attorney. Don't travel. Traveling can give rise to very serious immigration consequences, unfortunately. So even traveling within the United States can, but especially leaving the United States. And then keep any evidence that you might have that you've been here in the United States for over 2 years, that you're a lawful permanent resident. Make sure you have at least a copy of your green card in your wallet, or if you have a work permit, keep that in your wallet. If you have an upcoming hearing, the hearing notice, just any type of proof that you've been here for over 2 years, because they have started those expedited removal proceedings against people who have been here for less than 2 years. So if immigrants encounter ICE at their home, they have the right to privacy. They need that judicial warrant. ICE needs that judicial warrant in order to enter your home without your permission. So what we recommend people do is, if ICE knocks on the door, don't open the door. Ask ICE to slide the warrant under the door or show it in a window so that you can confirm if they actually have a legitimate warrant. And of course, if they do have a legitimate warrant, they're not going to wait around for you to open the door. They might just enter without your permission, and they have the legal right to do that. If ICE enters and they do not have a judicial warrant, immigrants have the right to inform them that they don't have permission to enter your house and to ask them to leave. And I didn't include this here. They also have the right to remain silent. So after asking them to leave, we recommend people, if ICE keeps interrogating them, we recommend people say, I wish to remain silent and I wish to contact an attorney, and remain silent after that. In your car. So I think somebody asked us in the chat. Yes, cars are considered private spaces, although there is a little bit of a caveat, and I will explain that in a minute. So ICE can stop your car, and they can demand to see your license without a warrant. So if you're driving along and you're an immigrant, ICE can stop your car and ICE can demand to see your license. However, they cannot search your car, they cannot search your belongings, and they can't search your physical body without a warrant. So if you are stopped by ICE, you should ask if you're free to leave. And if they say yes, then anyone in that situation should leave. However, if they ask to see your driver's license, which is more likely, whoever's driving the car must give them the license. And if they state that you cannot leave, then we recommend that people say you wish to remain silent. If you're a passenger in the vehicle, you can decline to give your license. I think, this is something people may or may not be willing to do, but you can also assert your right to remain silent. So if you're the passenger, you can just say, I don't wish to answer your questions, and remain silent. They really just have a legal right to see the driver's license of the driver. So that's what we would recommend doing. And then, of course, if they ask to search your car, if they say they're going to search your car, if they say they want to search you, you can always decline that. And without a warrant, they cannot do that. If you're walking in public, it is a slightly different standard because you're in a public area, so they can stop you if they have they can detain you if they have reasonable suspicion. But reasonable suspicion is not the language you're speaking, and it's not the color of your skin. That's not sufficient reason to detain somebody. So they can ask you questions. You do not have to answer those questions. You can ask if you're free to leave, and if they don't have reasonable suspicion, you should be free to leave, and you should be allowed to leave. If they continue to ask you questions, then you can state that you wish to remain silent, and you do not need to show any ID, give name, or tell ICE your country of origin. So protections under labor law. Everyone in the Washington state has certain protections under labor laws. Immigrants have the same labor protections as any other worker in the state of Washington. They have the right to receive full pay for any work that they complete. They have the right to leave the workplace after the workday ends. They have the right to receive compensation for work injuries if they're injured. And any immigrants who've been subject to unfair labor practices may be eligible for temporary work permits under DALE, which is a new deferred action, which may have been paused. I have to look into that actually. But yeah, potentially they have the right to receive temporary work permits. And then we have been seeing an increase in work rates in immigration detention in general. If you want to receive text alerts regarding work rates in your community, you should text ICE or Migra to the 509 phone number, and you should receive text alerts. If you are present when a raid is happening or when you suspect a raid is happening, you can call this 1-844 number to report any raids in your area. If you or somebody you know is detained after a work raid or just for whatever reason, if they're detained at I think they now call it the Northwest Immigrant Processing Center in Tacoma, you can call us. That's our phone number for contacting us so we can provide them with some legal assistance. And we do recommend that anyone who's undocumented make some type of family plan. The Legal Council for Youth and Children has published a guide on how to draft this family plan, but that's just to establish who has custody to pick up your kids from school, to take their kids to medical appointments, who has, who can control your bank accounts, things like that in the event that you're detained and you're not able to care for your children. Okay, so I have looks like one question in the chat. Do private spaces include a car? Yes, they do need a warrant to search a car. What about videos of people being ripped out of cars? That's a great question. I think a couple of things could be happening there. If they have a judicial warrant, they can arrest somebody in their car. It's also possible that ICE is breaking the law and is arresting people without sufficient cause. So it's hard to say exactly what's going on without knowing what video, but it is both of those situations could be this reason why people are being ripped out of their car. Okay, so this hypo is a client comes to you and discloses that they are undocumented. They are afraid ICE will come to their home looking for them as a neighbor was recently arrested and deported by ICE. What can the client do to protect themselves if ICE knocks on the door? A, invite ICE into the house and answer all their questions. B, ask ICE if they have a warrant and open the door to see the warrant. Or C, ask ICE to show them the warrant through the window or under the door crack. Any ideas? Yes, C. We do recommend people not open the door in general, just because that could be viewed as consent to enter. I think it would be a legally not a completely black and white area. So we recommend people keep the door closed. Again, if they have a judicial warrant, they're going to come in with or without your permission. If they have the ICE warrant, then you can tell, if they slide it under the door or they show it in the window. So that's what we recommend people ask ICE to do. And then if they do have a judicial warrant, make sure the name is correct, that the person actually lives there, the address is correct. And then if all that information is correct and you want to save your door frame, go ahead and open the door. But if it's not the right person, not the right address, I would give them back the warrant and say, slide it back under the door, or just leave the door closed if people don't want to interact with ICE. What can the client do if ICE officers enter the house and begin interrogating them? So that's specifically if they enter the house but are not allowed into the house. If they break down the door, or if the door is unlocked and they just walk in. I'm gonna give it a couple minutes and then I might answer it, or a couple of seconds here. So we always talk like you have the right to remain silent, so they can remain silent. They have to assert that right. They can tell the officer, I want to remain silent. I don't want to talk right now. I want to talk to an attorney and remain silent. They can also ask the ICE officer to leave. And then for the second question, does your answer change if the client is worried about being stopped by ICE when the client is driving the car? So the client does have to show their driver's license. And, but besides that, they still have the right to remain silent. They still have the right not to answer any additional questions. If the ICE officer starts asking about where they're from, things like that, they can remain silent. Okay. Are there any questions before I move on to the next section? Okay. So there are certain Washington state specific protections for immigrants, and we'll go through those really quickly. So these are called, I think you've probably heard, sanctuary policies, welcoming policies. I think there's been a lot of discussion, especially from the Pierce County Sheriff, about whether or not these welcoming policies are illegal. And they are. They're based on the U.S. Constitution, the 10th Amendment right to prevent the federal government from compelling state and local government to use their local resources for federal purposes. So basically, the 10th Amendment really delineates the powers of the federal government and the powers from the state government. And the federal government can't commandeer federal or state resources, local resources, to conduct federal business. There is this 8 U.S. Code 1373, which I think people who are opposed to sanctuary policies sometimes cite to. And while this code does prohibit enacting a state law, this is a little double negative. So it says there can't be state laws prohibiting individuals from sharing information about a person's immigration status to ICE. However, this federal code does not say that local or state agencies have to take any action on behalf of ICE. Local and state agencies do not have to ask people about their immigration status, and local and state agencies, this law in and of itself does not prohibit policies against asking about immigration status. So it only prohibits the enactment of certain policies which limit sharing information about immigration status. Basically, this code is all about whether or not police agencies can share information to ICE. And police agencies they can share information with ICE. What police agencies cannot do is, at least in Washington state, and other agencies, not just police agencies, other agencies as well, is they can't. This code does not prohibit states from passing laws which prohibit agencies from asking about immigration status, and things like that. So it is a little confusing. There are a lot of double negatives, but basically it restricts, it doesn't allow restrictions on communications between agencies and ICE, but it does allow for restrictions on those agencies to inquire about a person's immigration status. It also does not say that agencies have to comply with ICE detainers because that would be unconstitutional. ICE detainers are arrest warrants. So the Keep Washington Working Act basically is a Washington state specific law that prohibits state agencies from asking about a person's immigration status unless it's expressly required under federal or state law. So there are some federal grants that can only be allow service to people who are U.S. citizens, and in those circumstances, these agencies can inquire about a person's immigration status, whether or not they're a U.S. citizen. But outside of these circumstances, local agencies and organizations under Keep Washington Working should not be inquiring about a person's immigration status. And specifically, what we've been seeing is, this can be a problem with law enforcement. Law enforcement, when they make a stop, should not be asking about where a person was born, whether or not they have lawful permanent residence, things like that. And they can't detain somebody just to determine whether or not they have immigration status, and they can't accept certain contracts with CBP or ICE. And this is because of the 10th Amendment. We cannot have local law enforcement agencies acting, being compelled to act by the federal government because they are a local state agency. They're not federally funded. They're funded by state resources, and they should be used for state purposes. There's also the Court Open to All Act, which applies to the Washington Supreme Court, courts of appeals, and superior courts, and protects people from warrantless civil immigration arrests at the courthouse. It's the same deal. It also prevents court staff, prosecutors from using local justice resources to report people for federal immigration enforcement. Okay, are there any questions about that? I hope that wasn't too confusing. Okay, I'm gonna give it a couple minutes and then we'll move on to the last section here. Recent developments in immigration law or immigration policy. Okay, so I think what might be pretty pertinent, a pretty big difference that happened a couple months ago, so maybe it's old news for most people now, but there was the DHS memorandum, the sensitive locations memorandum that was around for a few years, and that basically says ICE, the Department of Homeland Security, agrees that ICE should not be entering protected areas like schools and hospitals without some sort of real emergency situation. And so they were basically saying they're agreeing not to enter those locations. That memorandum has been rescinded, so they no longer have that policy where they're not going to enter those locations. We've also seen an increase in ICE raids and an increase in detention. So to give you some perspective on that, the Northwest Detention Center, or the Northwest Immigrant Processing Center here in Tacoma, I would say we're 6 months ago, there were about 800 people in that detention center pre the new administration. We just got reports yesterday that it was 1,575 people. So it's almost doubled, and it's been 30 people over capacity. So people have been forced to sleep on the floors of different facilities. They've been transferred to other detention facilities. So we are definitely seeing a marked increase in the number of people who are being detained. We are seeing cancellation of people's humanitarian parole under the CHNV program. So that's for people from Cuba, Haiti, Nicaragua, or Venezuela. That program has ended. And we're seeing a reduction of funding to resettlement programs that have resulted in really limited support systems for recent refugees and asylees. Agencies have been having to start depending on local state resources instead of this federal funding in order to provide resettlement assistance to recent arrivals. Oops. We also have seen, I think this has probably been all over the news, so many of you may have been aware of this, but we're now seeing that DHS has that's the Department of Homeland Security, ICE has the authority to detain immigrants and place them in expedited removal proceedings if they have not been continuously present in the United States for 2 years. So to give you some perspective, this is based on a statute. Previously, the way this has been enacted is that the DHS has pursued expedited removal against people who have been in the United States for less than 2 weeks. They've now expanded that to say anyone who's been in the United States for less than 2 years can be placed in expedited removal proceedings. And what we've been seeing that's pretty unprecedented is we've been seeing OPLA attorneys coordinating with ERO, the ICE enforcement and removal operations. So the OPLA attorney also are part of the Department of Homeland Security. They have been moving to dismiss cases in front of the immigration court, which 6 months ago would have been great. But now, once the case has been dismissed, the immigrant is being detained because immigration court proceedings are 240 proceedings, and those are different from expedited removal proceedings, which are 235 proceedings. So they're being detained after their case is dismissed, and they're being placed in 235 proceedings or expedited removal proceedings, which is a much faster process. It's hard to get legal representation in time to represent yourself in front of the credible fear interview. If you do have a fear of return and then you have to pass a credible fear interview, it might be for the second time because you may have already passed a credible fear interview and then been placed into 240 proceedings. So it's kind of it's kind of a ridiculous situation, but it is unfortunately resulting in many people being very afraid to appear to immigration court. And also these horrible videos of people being arrested in the courthouse after they think maybe their case has been dismissed. We're also seeing an increase in people being detained during their ICE check-in. We have seen that this mostly still applies to people who have final orders of deportation and recent criminal history, but it has also applied to, we have seen some instances where it applied to somebody who's just doing, no recent criminal history, no deportation, and they're still given a notice that they're going to be detained, and they're detained. And then just last week, we saw a travel ban for 12 countries. So we're sort of sorting out how that's going to affect our clients right now. And then a partial restriction for 7 other countries. And we still have the birthright citizen executive order going through the courts. And hopefully that will be enjoined, but we don't know at this point what's going to happen with that. Okay, so there are some questions in the chat. Do you recommend people attend their immigration appointment? There's a lot of fear due to arrests being conducted immediately after appointments. So there is a lot of fear, and unfortunately, it's hard to give good legal advice right now because I would say the administration is not always acting lawfully. We do still recommend people go to their ICE check-ins and to their hearings. We recommend that you go with somebody who is ideally your attorney, but if your attorney can't make it, somebody who's a U.S. citizen, somebody who can call your attorney or call an attorney if you are detained. If you don't go to your immigration court hearing, you will probably be ordered deported in absentia. So we are still telling people you have to go to your immigration hearing. The consequences for not going are pretty dire. If you don't go to your ICE check-in, there can be a warrant issued for your arrest, and it probably would be an ICE warrant, but it could be a judicial warrant if they go to the federal court and request a judicial warrant. So we just recommend that people still go to their appointments and to their immigration court hearings, but just that they are prepared for something to go south if they do go. Is WIC considered a sensitive location? That's interesting. I'm not 100% sure. It's a social service provider, so maybe if it's attached to a hospital or a school or something like that, it could be considered a sensitive location. That memo is no longer in place, so there are no more sensitive locations, unfortunately. I'm not sure if WIC would have been considered one or not, however. What ways to show residence in the US for 2 years? Another good question. What we always, I mean, we have to do a lot of applications where we have to establish that we've been in the United States or the client's been in the United States for a certain period of time. I would say things like if they don't have a work permit that was issued, over 2 years ago, they might want to have some phone bills or photocopies, maybe is better, of phone bills, maybe pictures in their phone of bills, of any ID, driver's license, things like that have been issued over 2 years ago. That would be valid. If they have an immigration court hearing, if they have a hearing notice that was issued over 2 years ago, that would also be good type of evidence. But any type of ID that was issued over 2 years ago, anything with their address, name, and a date, those are good evidence for showing residence and time periods. Okay, are there any other questions before I wrap up here? I give it a couple minutes. How do you not feel helpless? Very hard not to feel helpless. I think, I think all of us in this field feel pretty upset and angry about the situation right now. I think staying focused on, your client situation and how you can help them and what you can do to help them. There are still things to do to help people. So just focusing on what's left, I think is what we've been doing for the most part. Would any of this constitute an obstruction of justice? What to do if the threat is given or implied? Can you be a little more specific, Marissa? And here are some resources at the end. I'm happy to share these slides if that's okay. But we do have some resources on our website that you can find, including the advisory to nonprofit organization, any work-paid race response, and information about Keep Washington Working and safety planning. Yeah, I think there has probably been quite a bit of obstruction of justice happening. Some of it, and I think, there are a lot of lawsuits probably in the works right now. Part of the problem is the Trump administration was very effective first time around at instituting friendly judges, the judges that are friendly to them. So yes, if you don't show driver's, oh, I see. So yes, if you don't show your driver's license and you are the driver, you can be arrested by ICE, and that would be a lawful a lawful arrest. Receptionist holding ICE in the waiting room, I would say don't get physical. They're not good. They shouldn't be arresting anyone for obstruction of justice for saying, please wait. But don't get in their way. Don't try to put your hands on ICE. Just, if they come into the building anyway, the receptionist should not try to physically prevent them from doing that. And they shouldn't be arrested if they're just saying, we need to see a warrant. Have there been any consequences for ICE officers? Very rarely is there a consequence for ICE officers. What usually happens is if somebody is unlawfully detained, they get placed in removal proceedings. Those removal proceedings can be terminated. There could be a civil lawsuit as well. I don't do a lot of civil lawsuit work, so I don't know much about that, but I do know that we can get their proceedings potentially terminated or that evidence collected by the ICE officer suppressed from the court. All right. That is all from me.
Camila, thank you so much for sharing this information with us, for the work that you do, for the weight that you are holding right now. We see you and we are so grateful for you.
Thank you. I really appreciate it.
Yeah, this is a really horrible time and really grateful to have champions like you doing it. To everyone, this is a really hard time that we're in, and we hear in your questions the gravity and the weight that you're trying to hold for the families that you're supporting. And so please do take care of yourselves, and do what you need to care for yourselves and your people. We are going to move forward. We're shifting gears a little bit, and we're going to talk about preventing preventable syphilis, and the transmission of it to fetuses and babies. And so Emily Gregersen should be joining me today. I see you. Hi, welcome, and thank you so much. I'm going to give you power to present. And I'm happy to share your slides, or Kendra will share your slides if you would prefer that. Here they come. Wonderful. We can see your working deck. Perfect. Thank you so much for being here. I'll let you introduce yourself. Thanks. You are muted though.
Okay, there we go.
And then just reshare
Yeah.
the presentation, please. Perfect. You're
Okay.
good to go. Thank
Okay.
you.
So my name is Emily Gregersen, and I'm the DIS supervisor at the Tacoma Pierce County Health Department. And I'm here to talk to you guys about congenital syphilis today. So we're gonna just talk about a quick program overview and staff. We'll talk about what is syphilis, syphilis in Pierce County, and then we'll talk about congenital syphilis and data and our program response. So our STI program overview. So what we do is here at the STI program, we receive reports for gonorrhea, chlamydia, syphilis, and HIV. We investigate, we interview, and we refer patients for services. We do provider education and consultation on a daily basis. And we prioritize syphilis and HIV due to our increasingly limited resources. Our program staff is made up of 2 disease investigation technicians, which enter chlamydia and gonorrhea data into our state's database. They entered upwards of 6,000 clients in 2003. We have 4 DIS, disease investigation specialists, who investigate and interview new syphilis and HIV cases, upwards of over 700 cases in 2023. And they follow up with partners that are elicited from interviews. We have 1 DIS supervisor who investigates and interviews new syphilis and HIV cases and partners elicited and supervises the DIS team. We have a registered nurse who tests and treats patients in our clinic and in the field. In 2023, we treated about 682 patients in the clinic and about 81 in the field. And then we have a clinic coordinator who supervises the clinic and assists with data entry. And we have a program manager who manages the entire program. So what is syphilis and why do we care? Syphilis is a sexually transmitted disease. It's spread through contact with infectious symptoms like sores. It's diagnosed with a blood test. It's very easily treatable. If untreated, it has the potential to cause significant damage. It can be transmitted from a pregnant individual to their unborn baby, and it can cause miscarriages, stillbirths, neurosyphilis, ocular syphilis, and even death. So evaluating patients for syphilis. Sexually active people should be tested for syphilis at least once a year. For sexually active people, including those who are pregnant, or for any of those people with these risk factors, people who are injecting or smoking drugs that can be injected, those using methamphetamine or non-prescription opioids, those living homeless or unstably housed, those exchanging sex for money, drugs, or housing, or those who have been incarcerated in the past 2 years, those people should be tested every 3 months. And a person with any of those risk factors should also be tested for HIV, hepatitis C, gonorrhea, and chlamydia every 3 months. So the syphilis stages. So the stages of syphilis are primary, secondary, early latent, late latent, tertiary, neuro, ocular, and otic syphilis, and congenital syphilis. So starting with primary syphilis, it's typically a painless sore, which is the first symptom. It can be one sore, but it can also be multiple sores. The first symptom, the sore, is highly infectious. It's often misdiagnosed because it's mistaken as an ingrown hair. It can appear within days or as long as a few months after the exposure. It develops on the body parts used for sex. So vaginas, anus, it can, hands for hand jobs, mouth. It may not be noticed if it's on the inside of the vagina or the anus because the sore is painless. The sore heals and resolves on its own, even without treatment. And it may overlap with secondary symptoms. So secondary syphilis. Secondary syphilis symptoms typically last a few weeks. There's many different examples. Secondary syphilis symptoms heals and resolves on their own, even without treatment. And secondary symptoms include different things like rashes. There's one called palmar plantar rash, which happens on the palms of your hands or the soles of your feet. But the rashes can come in many different places, including the body, the trunk, the face, the arms, the chest. So it can be misdiagnosed because it takes many different forms. Alopecia is another symptom of secondary syphilis. Swollen lymph nodes. These are not infectious. The rashes, alopecia, and swollen lymph nodes are not infectious. The highly infectious parts of secondary syphilis are the mucus patches, which are found on the mucous membranes, so the mouth, the vagina, the anus, and condylomata lata, which is highly infectious as well. And it's moist wart-like lesions found on the anus, the vagina, and the penis. Sorry. So the next stage, you have early latent and late latent. So early latent syphilis, the time frame is within the first 12 months after infection. The symptoms, there are none. You're typically asymptomatic, but the infection is still present. Contagious, potentially, especially if if you relapse into secondary symptoms, which can happen during early latent syphilis. For late latent syphilis, the time frame is that the infection has lasted more than 12 months. There are no symptoms, you're asymptomatic, but the infection is still present. You are not contagious, but again, it is still very serious. Having late latent syphilis represents a hidden ongoing infection that can cause really serious major complications later if untreated. So syphilis complications. The things we're talking about are neurosyphilis, ocular syphilis, and otic syphilis. So these can occur at any stage of syphilis, especially in early stages like primary and secondary. A lot of people tend to think that neuro and ocular syphilis don't happen until 10 years after you've been diagnosed with syphilis, but a lot of times it happens during the primary and secondary stages. Neuro, ocular, and otic syphilis are not infectious. They may mimic meningitis or stroke-like symptoms. You can have acute altered mental status, visual abnormalities, or auditory or otic abnormalities. And if untreated, syphilis can lead to permanent neurologic and physical damage. So this is just kind of it's a diagram that just kind of shows us the untreated syphilis progression. So basically it starts with your exposure, and then you incubate that, it moves to infection, which you start with the primary infection. Untreated, that moves to secondary. Untreated, that moves to early latent syphilis, under a year, under 12 months. Over 12 months of having syphilis means you have late latent syphilis. After those 12 months, you then would move on to when you would then deal with things like having tertiary syphilis, which is when you're dealing with cardiovascular issues or gamaceous lesions, late neurosyphilis, late ocular and otic syphilis. And then anytime you're being diagnosed with early neurosyphilis or early ocular and otic syphilis, that's when you're diagnosed early in primary or secondary stages. So syphilis diagnosis and treatment. So the diagnosis and treatment of syphilis requires a blood test specific for syphilis. So a provider needs to order 2 separate tests to confirm syphilis. Evaluating blood tests is very complex. The results need to be compared to any previous test results for that patient. A person may continue to test positive after they've been treated. A lot of times the EIA or antibodies will test positive for lifetime. So it can often be confusing when a person has been treated, but they still come back positive for syphilis. So we have a registry that we can look into and look at the whole history of a patient's syphilis history and kind of really determine whether a patient has a new infection or if it's just a previous infection, a serology result. So it can be confusing, but that's why we really encourage providers to reach out to us directly so that we can work with them to determine whether these infections are new or old. So again, it's done in conjunction with current symptoms or history of symptoms. There's no immunity to syphilis. There's no vaccine. People often get reinfected, usually from untreated partners. The treatment for syphilis is an injection of benzathine penicillin or Bicillin. There's a 90 to 100% cure rate. The number of injections for treatment, it varies depending on the staging or the stage that the person gets diagnosed with. If they get diagnosed with primary or secondary or early latent, they'll get treated with 2.4 million units of Bicillin. If they get diagnosed with late latent syphilis, they get treated with 3 weekly doses of Bicillin. So it depends, the treatment depends on the stage of syphilis they get diagnosed with. And some people will need to take doxycycline if they are allergic to penicillin. So syphilis data. Syphilis on a national level. The majority of cases right now are among heterosexuals, but the rates are still high among men who have sex with men. So we kind of have 2 co-occurring outbreaks of syphilis right now. So although the majority of our cases are among heterosexuals, we're seeing that right now, it doesn't mean that our MSM population or men who have sex with men population is not dealing with the outbreak that we've seen prior to this. They are still dealing with that outbreak just as much as they have been before. So we're just dealing with 2 co-occurring outbreaks right now. The rates of primary and secondary syphilis in women has increased 108% during 2019 to 2023. And this is just incredibly concerning because of the link to congenital syphilis. Congenital syphilis has increased 254% during 2016 to 2020. It increased 106% during 2019 to 2023. It is leveling off, but that's still about 4,000 babies each year. Syphilis in Pierce County. Just like national levels. What we see here in Pierce County is similar to that. The majority of cases are now among heterosexuals. Excuse me. And a significant portion of our cases are houseless and using meth and or fentanyl. The rates are still high, but rates are still high among men who have sex with men. So in 2020, our cases were reporting about 6% of early cases were unstably housed, and we had 2 congenital cases at that time. In 2021, about 12% of our early cases were reporting being unstably housed, and we had 14 congenital cases at that time, which happened to be the most of any local health jurisdiction in Washington. Then in 2022, 19% were reporting being unstably housed, and again, we had 14 congenital cases at that time. In 2023, we had 26% reporting being unstably housed, and another 14 congenital syphilis cases. In 2024, we had 22% reporting being unstably housed and 22 congenital syphilis cases. And as of 2025, to date, this data will change. We've had, so about 35% to date of early cases are reporting being unstably housed. And I know it says 4 congenital cases to date, but that has changed since we did this, and we have 6 probable cases to date so far. So congenital syphilis, it's transmitted from a pregnant person to with syphilis to an unborn fetus. The treatment for an adult during pregnancy is benzamine penicillin injections, and again, it does depend on what stage the pregnant person is. It depends on what she'll get during her pregnancy. To avoid a congenital syphilis classification, the treatment does need to be completed 1 month prior to the baby being born. The treatment for the infant is 10 days of IV aqueous penicillin in hospital. The preventable outcomes for this, miscarriage, stillbirth, prematurity, low birth weight, permanent neurologic and physical damage, and death shortly after birth. So congenital syphilis on a national level. This slide is always just really concerning to me, if just looking at it and looking at American Indian Alaska Native, their number of cases and cases per 100,000 births is shocking. AIAN communities experience significantly higher rates of congenital syphilis due to several systemic factors, including limited access to prenatal care, underfunded healthcare infrastructure in tribal and rural areas, historical and ongoing impacts of systemic racism, gaps in STI screening and treatment during pregnancy, maternal and infant health inequities. There's a number of reasons that they're dealing with this, but it's just really, really stark and sticks out. Congenital syphilis in Washington State. So in 2023, the total number of congenital syphilis cases we had was 57. Of those, 36 had no or untimely testing, 10 had inadequate treatment, and 7 had no or non-documented treatment. Many Pierce County congenital cases don't receive prenatal care or testing during pregnancy, which just highlights the need there's the barrier. These women are not seeking prenatal care. They're not getting in for routine labs. It's a big barrier. So congenital syphilis in Pierce County. Congenital syphilis cases remain high in Pierce County. The contributing factors are multiple sex partners, or they have a partner with multiple sex partners, sex in conjunction with drug use, methamphetamine or other substance use, transactional sex, late or no prenatal care, incarceration of the pregnant person or their partner, and unstably housed. So some of the laws and recommendations for pregnancy and testing for syphilis. We recently put out a health advisory outlining the recommendations from the American College of Obstetrics and Gynecology, the Washington Department of Health, and the Washington Healthcare Authority, that all pregnant people should receive syphilis testing 3 times during their pregnancy, at their first prenatal care visit, at 24 to 28 weeks gestation, and at delivery. There's the Washington state law that requires all pregnant women be tested for syphilis at their first visit to any healthcare provider while pregnant. And the Center for Disease Control and Prevention recommendations recommends additional testing at 28 weeks gestation and again at delivery for women who are at higher risk or were not previously tested. And there's links included that you guys can go and check those out. So just some syphilis talking points. Syphilis is so incredibly easy to treat with penicillin injections. It's incredibly easy to treat. If a pregnant female is allergic to penicillin, she does have to get desensitized to penicillin. There's no other treatment available. So she will have to be hospitalized and desensitized to the penicillin and then receive the penicillin injections for treatment. Anyone who's had sex, oral, anal, or vaginal, can get syphilis. If they have sex with someone who has the disease, they're at risk of getting it. It's spread through contact with infectious signs or symptoms that don't hurt. The first symptom develops on the body part used for sex. Pregnant people with syphilis can pass it to the unborn baby. Even without treatment, symptoms will go away. The disease is still damaging the person's body, including neurologically. Many people with syphilis don't know they have it. They may not recognize it or even see the symptoms. Washing your genitals, urinating, or douching after sex will not prevent syphilis. Get tested each time you change your sex partners. And condom use can prevent STDs if used correctly and consistently. And then this is just the staff at our program, which I won't go through. I'll just go through really quickly. Our disease investigation technicians are Jocelyn and Tay.
Sorry, Emily, we're just a bit over time, and I love that you want to plug your team.
Yeah.
And Emily works with an incredible team, and we are all very grateful. But and I'm going to ask that you jump to the next slide with your contact information.
Yep.
Thank you so much. We unfortunately don't have time for questions, but here is Emily's contact, and I'm also going to put it in the chat, y'all. And so please follow up with her if you have questions, or go ahead and put them in the chat too. And Emily can maybe answer them in the chat. Would you be able to do that? Thank you so much. We are so grateful for the work you and your team are doing in helping prevent syphilis. Our goal is 0 cases, so thank you. We have one more presentation. Kate, do you have slides? You do?
I do, yeah.
Wonderful.
Do you have them, or do I need to share?
Here. Without further ado, this is our new segment, Perinatal Shoutout. So this is an opportunity, if you or your agency want to have an opportunity at the end of these meetings to plug the work you are doing, or share changes that are happening, or promote what's happening, this is a great opportunity, and you can reach out to any of us at the agency, and I'll put my email in the chat, and we can get you on the agenda. And we're here lucky to have First 5 Fundamentals presenting today. And if we have time after Kate's done, we'll open it up, but feel free to put any information for your agencies that you want folks knowing about in the chat. Kate, the floor is yours. Thanks for being here.
Hey, Kate, real quick,
Great.
This is Kendra. Did you want me to keep your slides up, or did you want to control yourself and share your screen?
If you can control them, that would be great.
I gotcha.
I
All
prefer
right.
that. And I think I'm pretty good at being quick, so I'm cognizant of the time. And I think people are already familiar, so I really wanted to focus on giving a quick update about Family Connects Pierce County. So hello everyone. Speaking of updates, this is a picture of my family, but that baby girl is now 5 years old. So that's about how long we've been doing this. Since March 2021 is when we kicked off really with looking through first 5 fundamentals as the support agency to the Pierce County Early Childhood Network, looking at how we could increase and expand support for families with newborns in our county in partnership with maternity support services and other existing programs. So looking at who wasn't being served and who was being missed by current services, and identified the Family Connects model of universally offered brief nurse visits as a way to do that. Next slide. So we are still, just for those, if you aren't familiar with the model, it's 1 to 3 nurse visits in a baby's first 3 months of life. I see that Anissa's off camera, so she can correct me if I mess anything up, because she is the expert, the clinical nursing director who's housed at Hope Sparks. So as first 5, we manage the contracts and kind of act as a fiscal sponsor to the initiative, but it's implemented through Hope Sparks, step-by-step family support with St. Joe's, and answers counseling with Tacoma General. So that's really the role we play in the community, is not to do direct services, but to support services that include multiple organizations to provide coverage. So it is a nurse who does the visit. They do a medical check of parent and baby. I received this myself with my son, who's almost 3. So when he was born, was able to have a nurse from Step by Step come visit my family. And what I would just say, even as a person who does this for work and is really familiar with what the community resources are, right, it's still super helpful to have somebody spend an hour or 2 really going through everything with you and how baby's doing, how your body's feeling. It's just not the kind of time you get at the pediatrician's office. Next slide. Family Connects, and part of the reason we are interested in this as an evidence-based model was because of the evidence around preventing child welfare involvement, which has been a focus for Pierce County Early Childhood Network, as well as reducing ER visits in a child's first year of life. So helping provide a little more upfront follow-up care, reduction in anxiety for birthing parents, and really acting, because it's so brief, acting as a referral to other more long-term community-based services, depending on what the family needs. Next slide. So Family Connects International, from their perspective, this is their aggregate data from across the United States. The model is now in 20 states. In Washington State, it is only in Pierce County, but in Oregon, they do have a statewide model based on the legislature passing legislation for insurance to cover at least 1 of those 3 visits and subsidize the cost of visits. So we're certainly always looking at sustainable funding and options for that in Washington State as well. And that's why our website is familyconnectslaw.org, not Family Connects Pierce County. We do have hopes for those who want it and who need more postpartum support in their areas to be a support to other areas as well. Next slide. These are the domains that the nurse checks in on during that integrated home visit. So the primary visit that occurs around 3 weeks postpartum, the 3-week timeline being a good time to check for perinatal mood and anxiety disorders after kind of the typical baby blues period. And they also screen for substance abuse and intimate partner violence. I think I have another slide on kind of the top concerns and referrals made for Pierce County families. I don't know, is that next? Go ahead, Kendra. Sorry, I'm going so quick because I'm aware of the time. And these are all the things they can help with. Certainly just talking through typical crying, safe sleep is a big one that comes up a lot. And really part of the value of a home visit is to see the environment to help families give tips on on safe sleep and how to set up the home environment for the child, as well as to provide some in-person lactation services. I know we have at least a couple of the nurses who are also IBCLCs. 3, Anissa says, yes. Next slide. In Pierce County, it is a universal model, but of course we don't have the capacity right now to serve. I think there's around 11,000 births per year in Pierce County currently. So we have expanded based on zip code while looking at the data of need, and then the need is around child welfare removals and other indicators of health inequity. Ooh, I put this in my notes. So St. Joe's, I think, is only still the 3 zip codes in terms of who is offered. 4 zip codes, thank you, of who's offered the support at the time of birth. And Tacoma General, they have capacity to do a bit more. We also, there's a self-referral and a provider referral, easy, simple form to fill out on the website for those who are not in the zip codes, because there still has been capacity to serve just those who are interested if they would like it and they ask for it. Next slide. Here's where we are at in terms of family served. So we almost hit 1,000 last year, and we are now celebrating 3,000 families served since starting in March 2021. Next slide. Here's the one I was mentioning. So I think the material support, I guess I didn't replace it with the one that wasn't cut off. Material support comes up a lot because of letting people know about diaper banks or other access to basic needs, things that kind of apply to everyone, as well as mental health supports available in the community. But these are kind of the areas that come up for a lot of families have questions about childcare, even with a newborn, because it's like, do I need to get on wait list now? Yes, you do, right? So this is what's coming up to date, or since March last year. Next slide. Blue bands, I'm running out of time, but we are also doing blood pressure cuffs for those who are at risk of eclampsia. Yes? Okay. Okay, Anissa's gonna correct me. You want to come on?
Preeclampsia, yes.
Preeclampsia, yes. So we've been able to participate with this initiative as well and get access to blood pressure cuffs. Next slide. Maybe you can answer that in the chat, Anissa, the questions in the chat. Baby lounges is something we started because of so many families saying they wanted social support, which is not something you can get through Family Connects. So we're supporting groups that are already happening in the community. And those are also on the Family Connects website for people can look up groups in their area. Mostly in person. We have had a virtual one, but that was the least well attended. So it just was like, spoke to us after COVID of people really wanting to be back in person. Melanin and Milk is weekly for lactation support. Caminemos Juntos is for Spanish speaking families. So those are available for families to drop into, meet others with kids 0 to 1 or people who are pregnant. And I think that's about it. I'll leave my contact or the info at Family Connects contact that does go to Anissa. Sorry, Anissa. But yeah, that was my brief update, and feel free to email with other questions we can answer. So thank you all. I'm sure a lot of people recognize this familiar face too. She's been doing our baby lounge in the Key Peninsula.
That's sweet faces, Evelyn, Patrick. Thank you, Kate and Anissa. Really appreciate that update. I'm sorry you rushed through it, but it was really helpful to hear. Kate's just put her email in the chat. Please don't hesitate to reach out to her if you have questions, and I'm sure Anissa will help answer those questions as the clinical director of Family Connects. We will next convene on September 8th. And you will also be hearing about our October 23rd conference coming up this fall. It is in person. We are working hard to get you CEUs, and we would love you all to be there. It will be at the environmental services building above Chambers Bay, which we all love so much. We would love your feedback on this meeting. As always, the QR code is on the screen. I want to thank all the presenters, Camila, Emily, Kate. Thank you, thank you, thank you. Thank you, Anissa. Thank you to Kendra. Again, the conference date is October 23rd. Please take care of yourselves so that you can take care of your families. The work you are doing is intergenerationally healing and so important. And I thank you all for being with us today, and I hope you have a great rest of your day. Again, our slides, our presentation is all on our website, and we're grateful to be in community with you all. Thank you, everyone.